Hi, short video on how to use Westlaw to research your trial brief issue surrounding the hockey fight in Ohio. Keep in mind, I can't go into a lot of detail in this video, but regardless, you will have access to a handout that goes into a lot of depth and has hyperlinks so that you can quickly click a link and run a search or identify documents. One other thing I wanted to point out before I get into the substantive part of the presentation, you're going to be approaching this from two perspectives. You're going to be looking at this as an intentional or reckless tort, as well as approaching it from the negligence perspective. Now, when you run those searches, you're going to be running them as global searches. And again, from first semester, you remember this. When you run a search as a global search, you're going to retrieve content type from 14 different content categories. Always start with secondary sources for three reasons. One, they're going to give you background on an issue that's unfamiliar to you. Two, they're going to let you know which of the three branches of government covers that issue you are researching. Cases, statutes, regs, or a combination of those three. And three, every secondary source provides you with hyperlinks to the primary sources they control. So, like with your open memo, if you get good secondary sources, 80 to 90% of your research is done. Now, for this particular issue, I do want to point out that there's some really good national practice-based secondary sources, as well as some real good Ohio practice-based secondary sources. Let's talk about the national ones first. And by the way, what I would probably do to sort of filter this list a little bit, I tend to start looking for ALRs, American Law Report annotations. So you could filter to publication type to just look at those first. And one that's going to be really interesting because this looks like a new perspective on this particular tort is there is a contact sports exception to negligence now that many jurisdictions recognize. So you're going to want to take a look at that. This is a lengthy article. It's over 100 pages long. If you're only interested in Ohio or parts of this article where they reference cases from Ohio, here's the shortcut. On the left-hand side, scroll down, select Ohio, click apply, and this will just locate authority by jurisdiction. And in other words, it's only going to highlight the parts of this particular article where they talk about an Ohio case. So it's just a quick way for you to go to the best parts for you of this particular article. Another really good thing about this particular feature, if I click this arrow here, it's taking me to a table of cases. Here are, what is it, about 7 or 8 cases in Ohio you can use to jump off when researching this particular issue. Okay, so that's that national-based secondary source. Your next step would be to try to limit and retrieve Ohio practice-based secondary sources. How do you do that? Well, again, use your filters. Go to jurisdiction this time, select Ohio, click apply. You knocked it down to 9 secondary sources. And Ohio is one of those states that has multiple practice series. So you'll see something called Ohio Jurisprudence, Baldwin's. Both are really good resources. There are multiple chapters from both of these providers on this specific issue that you were researching. If I take a look at, for example, Baldwin's, I'm getting that background on this particular issue. I am getting these hyperlinks to the primary sources that control, and really getting that foundation that I need, to really argue this particular issue. Another really nice thing about these types of secondary sources, there's a table of contents on the left-hand side. So, while some of these chapters we probably retrieved as a result of this keyword search, take a look at that table of contents, and you oftentimes can just go from section to section to get more detail on this issue. Another tip, make sure you're foldering these items, whether they are secondary sources or cases. Keep in mind, you're going to want to create a new folder, call it trial brief, hockey fight, whatever. But the benefit of saving items to folders, I'm going to talk about that towards the end of the presentation. But just from this particular article in the ALR, we really have a nice jumping off point of relevant cases. And before I leap over and talk about cases, two final content types that you really want to start looking at anytime you're researching issues going forward. You might not have done this with the open memo, but certainly you want to do this for the trial brief. When you run a global search like I just did, as I said earlier, it's looking for items in 14 different content categories. And we're not displaying all of them at this point. You have to click Show More to display the rest of them. But the two that I want you to start looking at a little bit closer than you have in the past are appellate briefs and trial court documents. You are actually writing, as I recall, a memo in support or opposition to summary judgment. This is a real nice way for you to get actual documents that real attorneys submitted on these particular issues. And I'm not saying you're going to want to copy and pass this off as your own, but you sort of use them like those secondary sources that I talked about earlier as a way to get background on the issue, to confirm that you got all the relevant cases, as well as maybe as a way for you to know how to structure your particular argument when you write your memo or your brief in support or opposition to that summary judgment motion. All right, now I've looked at some good secondary sources. I've looked at some trial court documents. I'm now going to click and take a look at cases. Some of these we've probably theoretically read already because we got them from those secondary sources and trial court documents. But two that popped up for me that I just wanted to talk about quickly are Marchetti and Thompson. And keep in mind, Thompson, don't make the mistake a lot of students make. Just because they see a red flag, they think they can't use the case. If you see a red flag and your case was reversed on appeal by a higher authority, absolutely don't use it. Go to the higher reversing authority. On the other hand, if the most negative thing attached to your case, and we give you this right on the face of the document itself, if the most negative treatment afforded your case says disapproved of by, overruled by, or abrogated by, it's letting you know that your case wasn't reversed directly on appeal, but that this case invalidated at least one of the issues in your case. And as long as you don't cite your case for the issue that is no longer good, you're fine. Now, how do I identify which issues are good or bad? Well, the first thing you'd want to do is kind of go through and see which issues look good from this case. And frankly, this case contains 6 issues. All of them look really good. The one that is no longer good, and I'm going to save you some time, is issue number 1. Now, how do I know that? Well, I click negative treatment. I see that Anderson invalidated issue number 1. In fact, if you click on Anderson, we give you an easy way, once we get to that case, of seeing what they were talking about. What did they invalidate in our case? And here they talk about Thompson. And really, you don't have to worry about this. Basically, the Thompson case in a footnote said that the terms willful, wanton, and reckless were interchangeable. And Anderson said, no, they're not. They are distinct terms. So it's really not invalidating issue number 1. it's invalidating the the footnote that is referenced in headnote number 1, which is at the very bottom here. So don't worry about that red flag for Thompson, bottom line. The other thing I wanted to point out, I have a few more minutes here. When you're looking at cases on Westlaw, there's a feature that will retrieve all relevant cases for you on a particular issue. And you should know this already, but it's probably good for us to review it. Keep in mind that the first thing you would do is look at your head notes. The head notes are going to summarize each issue of law in the case. But, and here's where you've got this really good tip coming up. Every head note from every case has been placed somewhere in the topic and key number system. This specific issue that talks about the distinction between reckless, intentional, and maybe negligent has been classified to the topic negligence, subtopic defenses and mitigating circumstances, assumption of risk, sports, games, and recreation. You click that last number, it will automatically collect every case in Ohio classified to that specific point of law. Now you got 118. Tip here, some of these are talking about spectators. You don't care about that. So here's what I would do if I were you. Tell Westlaw, of these 118, you only want those that mention participant, but not spectator or fan. And when you do that, you're going to knock out a good percentage of them and get a much more relevant subset. We got it down to 26. These are listed in reverse chronological order. You want the seminal case in Ohio, sorted by most cited, and it confirms that Marchetti is the seminal cases in Ohio on that issue. In fact, there are 179 cases that cite to Marchetti for that specific point of law. I could click that link and automatically get all 179 cases that cite to Marchetti for that first issue. So that's another way of getting relevant cases. 2 final tips. I mentioned folders as a really good place to is a really good resource. Keep in mind that Westlaw has a number of safety nets. One of the safety nets is something called research recommendations. You'll see it pop up to the upper right from time to time. Basically, what Westlaw is doing when we're doing research, it sees where we're going and it's trying to be helpful and say, hey, I see that you're doing this research on sports-related torts. Based on that, let me suggest some potentially relevant cases, statutes, secondary sources. The other safety net exists in folders themselves, and this is why you want to folder everything. When you place items in a folder, you have access to something called folder analysis to the upper right. Westlaw is going to break down the common issues from the documents in your folder, and it's going to recommend documents that are no longer in your folder. Look at that. Issue number 1, liability for injury of participant in gamer contest. It's recommending 10 cases, 2 statutes, 9 secondary sources. Great way for you to make sure you got everything on a particular point of law. Final safety net and final tip. Once you are done researching, make sure, once you're done researching and you've finished the draft of your brief or the final version of your brief, make sure you are running it through Quick Check. Quick Check will analyze your document and let you know of any potential weaknesses, cases, and statutes you cited that are no longer good law. It will check your quotes for accuracy and let you know of any differences. And finally, it's going to go through your brief, and it's going to tell you that, hey, based on the argument you made here and the cases you cited, this might be a better case for you to use. So you should get into the habit of doing that. If you have any questions, let me know. Otherwise, good luck, and I will see you around.